Ready to take your verdicts and jury selection to the next level? Jury consultant Harry Plotkin and trial lawyer Dan Kramer are your ticket to tipping the scales before trial begins. You're not just picking a jury, you're picking justice. Produced and powered by LawPods.
All right. Welcome to episode 1 of Picking Justice. Harry Plotkin, why are we doing this? What are we doing here?
Woo, this is going to be fun, Dan. We're going to be teaching everything you could ever want to know and different approaches to jury selection. Because, as you know, and you're an amazing trial lawyer, I work with you all the time. Jury selection is probably the hardest thing you can ever do in a trial, right? I mean, everything else you can kind of script out and you know what's coming, but jury selection is, good luck scripting out what 50 strangers are going to say you to your face. Well, you're trying to figure out who's good and who's bad.
Yeah, no, 100%. I mean, that's one of the biggest reasons I think we got behind this was, as a young, up and coming, as a current, as a successful, wherever you are in your trial lawyer journey, I think one of the hardest things to do is pick a jury. And I think one of the hardest things to find was how to do it well, how to do it the right way, finding your own voice. And I remember I would scour the internet, YouTube, Spotify, anywhere, and just be like, I just want the jury selection stuff. I want to hear how these trial lawyers do it. How do they ask questions? How do they ask for money? How do they get cause challenges? What do they do if a judge gives them 20 minutes? I was looking for all of these tips because, like you said, you can't really script voir dire. You can have your plan, you can have your outline, your danger points and all that, but you are doing improv. Right? Like I just went to a comedy show last weekend with my wife, and it's one of the hardest skills. I remember talking to her. That's one of the hardest skills to do is get up there and be a comic in front of people. I think one of the second hardest skills, if not harder, is picking a jury in a case where you're the plaintiff lawyer and they're already coming in, not really liking your slip and fall case or whatever your case may be, and talking to them, being confident and really getting to know these people. So like you said, I think it's one of the hardest skills to do. So I approach Harry, who I love to death. I will not pick a jury without him as a jury consultant, just saying, look, we need to do a podcast that just focuses on how do you pick a jury? So that's why we're here, and we're excited. Harry, tell us about some of the guests we already got lined up who are going to teach us their different approaches.
Yeah, I mean, we got probably more people, guests, great, amazing trial lawyers from around the country signed up than we have time to film in the first year. But, Arash Homampour, Gary Dordick, David deRubertis, Ibiari Sec, Natalie Weatherford, who had 3 8-figure sex abuse verdicts last year. I mean,
she was just trial lawyer of the year.
Yeah, exactly. And the thing is, I'm excited about is that, I see a lot of mistakes get made in jury selection, and I can't train each and every lawyer, and you can't train each and every lawyer on all the little things that they're doing wrong that conventional wisdom has kind of told them, like, this is the way you're supposed to do it. And a lot of times it's like the opposite. And so I think that's why we're here and hoping you guys tune in every episode so you can not only learn what you may have been taught that is wrong, but also some kind of crazy things that some of the guests that we're going to have on do totally differently that may blow your mind and change your approach. So, and we're not afraid to get into the nitty gritty. I mean, we may have an episode just on how to warm up your jury, or we may have episodes just on, how to explain bias to them, or whatever it happens to be, how to get cause. So, and the magic words that you want to use. So, stick with us, and we're excited on this journey on training even better trial lawyers, for the future, and getting some big verdicts for all of you.
Yeah, and I think with a really effective, this is something I learned from you, Harry, it's a really effective, good, quality jury selection. You really can take maybe you have a tough venue or you hear it never gets good verdicts no matter what. But if you have a really good voir dire, a really solid voir dire, you can take away that defense benefit on maybe what's traditionally considered a bad venue. And actually, one of the interesting things, I mean, we're in the political season, right? We're all, I mean, when this aired, we are in the political season right now. Let's just say that, or it's just ending. But, one of the interesting things that I've talked to Harry about is, conservative jurors, for example. Traditionally, I think plaintiff lawyers would be like, you don't want any on our jury. But we just had this talk, I think a few days ago, Harry, on a case where you were talking about kind of the way you look at conservative jurors now compared to the quote unquote liberal jurors. What are you seeing out there?
Right. You'd be shocked at how many lawyers think that only the kind of jurors that match their politics are good for them. Obviously that's not the case. I've seen terrible liberal jurors and terrible conservative jurors and amazing conservative jurors, amazing liberal jurors. And it kind of depends on the person. So I think, one of the things is how do you figure out, how do you go beyond the labels for jurors, beyond their occupations and their politics a little bit and see what makes them tick and what pisses them off and what doesn't piss them off, what their expectations are. Because, I'm a big proponent of teaching people, don't ever judge, a juror by their cover. Don't ever have a list. I mean, I'm sure you've heard this from Dan. I'm lawyers who say, I would never keep, this and this and this type of juror on a jury. I would never keep an engineer. Or I would never
100%.
keep a nurse. I would never keep a lawyer. I always tell people, first of all, they're human beings first before they are their jobs or their politics or whatever their demographics. And so you got to dig a lot deeper and find out what really matters, because those things at the end of the day, don't matter. You can have bad jurors of every kind or good jurors of every kind. You just got to find the exceptions to the rule. And that's what, doing your job is all about. You could be lazy in jury selection and just sort of don't ask anything and make a lot of assumptions, or you can really dig deep and not necessarily a lot of time and find out like what your jurors are all about.
So then I guess you as the consultant, are you taking it, do you ever, I guess, factor in, the job or maybe even, the way their demographic, whether that's their race, their ethnicity, socioeconomic, religion, that kind of stuff? I mean, is that maybe a factor or a small factor or no factor at all? Or what are your thoughts on, considering that?
I think it's a factor. You think about it, if somebody comes in and they're an engineer, they're a CFO of a company and you're suing a company for, maybe putting, profits before people. And you're like, this juror, profits is all what their job is all about. But you don't ever, for me, don't ever make assumptions too quickly. You still want to treat them the same as the other jurors and find out how they feel about the core issues of the case, because they could be amazing for you. And I found lately, the last few years, a lot of kind of corporate jurors with corporate jobs tend to be pretty great in cases against companies. So you never want to assume anything. And so, but you do keep it in mind. And what I always say is, to the lawyer I'm working with, I don't want to go back there during a break and we're ready to pick the jury and you say, I feel like we got to strike juror number 3 because I just worry that he's going to feel or she's going to feel this way. And you're like, well, why didn't you ask him that? Ask him. If you have an engineer and you're worried that they're going to need a higher, amount of proof or something, it's a circumstantial evidence case, ask them, how do you feel about making a decision like that, without having, a videotape of what happened or whatever it is. And if they tell you what your assumptions kind of told you they would think, then that's fine. But, a lot of times they'll tell you, no, not at all. I'm an engineer. I got to make, calls based on little information all the time. That's what it's all about. So never make assumptions, but you can kind of, I do kind of keep it in mind as a little bit of a filter, but I never make a final decision on that. But one of the ways that I do, and you probably see this all the time, Dan, is like the defense lawyers are usually making stereotype assumptions. And so, okay, if this juror kind of fits what the defense thinks is good, and they turn out to be, we kind of like them, hey, that juror's going to make it on the jury if we keep him, because there's no way they're going to strike him, even if they say some good things for us. So that's one of the ways I like to keep it in mind and knowing who the defense is probably going to keep and strike.
Yeah, there's that old school. My first 4 years, I worked at an insurance defense firm. Great trial lawyers there, but they had the same method we still see to this day that honestly is also on the old school plaintiff side too. It's just that old school mentality that, like you said, you look at this person, what is their race, what do they do for a living? They're going to be good or bad for you, or good or bad for the other side. And I think that's another brings up another topic, is kind of that playing chess, right? If you know who your defense attorney is and you know that he or she is trained and will think that way, then you can almost bluff in a way, that that you really don't like that juror or whatnot. And then hopefully the defense either strikes or doesn't strike. And then, there's a lot of different ways you can kind of play that game. it's not even a game. It's just the strategy of how, as a defense attorney uses that old school thinking, I think you can kind of use that to your advantage and how you choose or not to get cause challenge or strike.
Yeah, it's kind of like we're playing chess and they're playing checkers when they're all locked in on some, total stereotype of a juror, and we're kind of assessing them on a little higher level, for sure. Because the funny thing is, I mean, I used to work with defense years ago before I kind of did only plaintiff, and one thing I found is that they have these like weird rules. This kind of a juror is always good, and this kind of a juror is always bad. I've heard like I would never keep a postal worker on the defense side, but they want to strike every teacher or social worker. But the funny thing is, it's like, where do they get that? Like, for me, it only comes from two places. Number one, it came from like your mentor told you this rule, and they probably got it from their mentor, and it probably goes like 70 years back, which is hilarious to think about that somebody's doing that. Or number two, it's like, once I got burned by a nurse, so I'm never going to keep a nurse again. And you're like, really? I mean, yeah, there's good and bad jurors of every kind. I mean, you name any occupation, I can tell you, I could probably think in my memory of somebody who was just awful that I struck, or somebody who was amazing that was like the foreperson of a jury. So, the sample size is just not enough. And there's no such thing as like some job where they're going to be 100% bad for you all the time.
Yeah, and I think anyone that's trying to sell you that bill of goods is they're leading you astray, because, and this is something that we try to build this podcast around. It's how to really get to know somebody get to know them on the jury. To ask the right questions, frame it the right way. So even if you only have 20 minutes, that you can get to know them, because labeling someone and doing quick stereotypical reads just based on demographics, like Harry's saying, is just, it's not going to work for your jury. In fact, I mean, Harry helped me pick the jury in San Bernardino, again, where we were suing the county. And my inclination was to strike all the county workers, because, that's their employer, and they're not going to want, 8 figures against the employer, especially their taxpayers and all that. It was Harry and actually the judge as well, when I was arguing super hard that, hey, this is their employer, they're not gonna want to hit a big verdict against their employer. He's like, I don't think you understand how government workers are and how they really feel that often about their employers. And sure enough, and I think you said something sort of similar. It's like, it's not always, even though that is an employer-employee relationship, which I think should be a cause, but it's not always the case, like we're talking about. Corporate employees don't necessarily always just want to back the corporation.
Oh, 100%. Yeah. And I remember that judge. It was funny because, I mean, it should be automatic that if one of your jurors works for the defendant that you're suing, that's implied bias. I remember our judge, though, who was great in every other respect, right? Was like, oh, we would never get if I excused every county employee, we would never get a jury here. And we're like, it's like 3 people, Your Honor, but, and I think like 2 of them were telling us like, I couldn't do it. And one of us was like, I don't care, and that juror, I think we kept that one juror. We had to strike the other 2. But and that juror was amazing. It was, and you got
super amazing. Yes, yeah. No, they were great. So it's interesting, it's just these, and that's one thing we want to avoid. One other topic I wanted to bring up that's kind of that I've learned, or mistakes I used to make, is really counting my stats on the cause challenges I get. And many of my colleagues, many of my close friends, great trial attorneys, they'd always talk about, oh, I picked a jury and I got 28 cause challenges. And, and I would brag about that stuff too. I'd be like, look, I must be crushing it on my cause challenges, the way I'm asking it. I'm just locking these people in, and it's just so proud of myself. And I'm doing it so well because I've read all these books and I know how to get people off for cause. And the more I get for cause, the better my jury is going to be. And again, Harry and I were picking a jury, and afterwards I thought I was doing a great job. He's going to high five me. And I was like, wasn't that just great? We had gotten like 14 or 15 cause challenges in a half day. And he just starts shaking his head. He's like, I don't know, man. He's like, I just feel like you really kind of undersold the case. You made it sound like it's like not even a good case at all, when it was a good case. Harry, explain what your thinking was and how you were able to change my mind on the way I approach it now.
Right. It's like one of those things where, the ability to get cause challenges is like a muscle that you need to have it. I mean, there's cases where you're going to need a lot of cause challenges because you may have a really tough issue. Like your plaintiff was drunk or something like that. And you're like, okay,
Yeah.
your plaintiff was on meth or something like that. But, it's like one of those things. You see the guy at the gym who's got like, a huge right arm from doing just curls with his right arm, and his left arm is puny. It's like, I just see a lot of lawyers who would just like, they're developing this like cause muscle and like neglecting the other parts of voir dire, which is just like actually listening to your jurors and assessing your jurors and trying to figure out who's actually maybe okay for you. And so like, I remember in that case, it was a pedestrian case, right? And, but sometimes there's like lawyers just are so focused on like what is it? If you're a hammer, everything you see is a nail, and like, let's just try to get everybody and make the case sound terrible. And you start to just kind of snowball sometimes, and you get like even good jurors saying like, I guess I can't be fair because it sounds like this pedestrian wasn't paying attention. And like, so if you're the lawyer there and you're like, in this case, like she was paying attention, like she wasn't out of the crosswalk. But some lawyers are just thinking, hey, if I just kind of don't correct this juror, I'm going to get more cause. Like, okay, tell me more about how you feel. And you couldn't be fair. And we're right behind, right? And more jurors are hearing this, even your good jurors, and they're going, wait a minute. If Dan is not, addressing that, it sounds like he's kind of agreeing that like this pedestrian wasn't in the crosswalk and wasn't paying any attention. And maybe they were on their iPhone or what, their earbuds are in or whatever. And you start to kind of lose good jurors. And so it's a snowball. And so, so you don't want to do that. You don't want to be like, I can get more cause. I think that's one of the things that judges hate too, when they kind of see you abusing, the case and not showing the full picture of a case just to get more
They do.
cause.
I've heard judges. I mean,
Yeah.
I think that judge is like, and I love great judge, and we had a really good relationship, but I think he was like, well, you really kind of poisoned the room here a little bit with how I was framing it. But it's these kind of things that you learn from, and you grow, and it's definitely, I've kind of changed the way I frame stuff now with the way, Harry, you've kind of showed me how in mini opening even, like how are you telling your trial lawyers to kind of frame those or weave those bad facts into the mini opening as opposed to telling all the bad facts, and what's your philosophy on that?
Right. I mean, we can spend an hour on that alone, but
Yeah, and we will.
Yeah. Oh yeah, for sure. But, kind of in a nutshell, you want to share your bad facts, but also promise that there's going to be good facts without actually telling them what your good facts are. I mean, you want to basically get in a position where at the end of your mini opening, all the really, really bad jurors are telling you, I don't need to hear anything more. I don't care what the rest of your evidence is. Like this plaintiff's at fault, like he did something stupid. And all your good jurors are like, I don't know if this case is a good case or a terrible case because you didn't really tell me. You told me, instead of saying like all the good things, instead of saying like the defendant driver was distracted and the defendant driver could have seen the pedestrian for 3 blocks or something like that, you're just saying, we're going to share with you, what the driver was doing, the defendant driver, and what their vision was like and what they could or couldn't have seen. And so they're just like, well, what are those things? But your good jurors are like, I need to hear more, and your bad jurors are like, I'm out. This is over. And so. But you want to, if you start to lose some of your jurors based on misconceptions, you definitely want to push back. I'm a big proponent of like your case kind of a good way, so that when jurors are telling you they don't like your case, they're really bad. You're not just tricking them. So, one good
So how are you
doing?
Yeah, go ahead. Yeah, how are you doing that?
Oh yeah. I'll give you a funny example that I did a couple of years ago. It was like a premises case where this guy was working out at a park in a city, and something felt like that was poorly maintained, like a sprinkler that was up on like a pole, like fell on his head. And, we did the mini opening, and then some of the jurors kind of just misunderstood it because the defense came up in their mini opening and said like, he was standing where he shouldn't have been standing. He was off the path. The truth was like, it was part of the park. Like he wasn't in some restricted area, but some of the jurors were like, hey, I feel like this plaintiff shouldn't have been there. He shouldn't have been where he was standing. He was told not to. And rather than push back and say, well, that's kind of disputed. I mean, can you decide that for yourselves? The lawyer was like, hey, I understand why you feel that way. So you can't be fair to us. And more jurors, you just see him in the back going, holy crap. Like, sounds like this plaintiff lawyer is just telling us all that, that's a fact and this case stinks, which was not true at all. So you definitely want to be sensitive to if your jurors are getting a misunderstanding, and don't just say, hey, great, awesome, this is a perfect opportunity to get more cause. Like, don't get more cause than you need. Don't run off good people for cause just because you can trick them. So you really want to be sparing on your cause for sure.
Well, let me just dig into that a little bit then. So a juror has a misconception of fact, right? And they're basically saying something that, is in dispute, but they're saying it as from the defense perspective. Maybe the defendant argued it or you didn't argue the good stuff. So a juror then comes back and says, well, if your plaintiff was doing this, there's no way I could be fair. You're saying in direct response to that, say, well, but do you know if that's true or not? Or how, like what's your direct response to that, to when the juror's just like, well, I can't.
Yeah, like let's take the night trial that we did together a couple of years ago where it was a pedestrian and everything. And so like if your plainterf really
that was the name of the case. That it wasn't done at night.
No, it wasn't night court. Yeah, it was. What a great show though. Wow. But anyway,
yeah, that would be.
It was. So let's say your pedestrian really was outside of the crosswalk, and the defense brings that up. Like, then you use it. Then you're like, okay, so I mean, does it not matter what are you telling me that if my plaintiff wasn't in the crosswalk, doesn't matter what the defendant was doing, like the plaintiff has all the fault or most of the fault or something like that, and then you can go with it and get that cause. But if it's like disputed, if you think you're going to show that they were in the crosswalk and the defendant is saying otherwise, and someone's like, your plaintiff was at fault, they weren't in the crosswalk, you definitely say, well, I mean, that's disputed in this case. So what I really want to know is like, does it matter to you? Does the evidence matter to you? Because tell me, I mean, brutal honesty, if it doesn't make a difference to you, if you think this plaintiff is responsible for no matter where, if they were in or out, then tell me. But does it, and so, bad jurors will say, yeah, they should have been paying more attention. Doesn't matter if they were in the crosswalk. Then you can get them for cause. But if they're a good juror, they're going to be like, no, it does matter. I mean, I'd want to hear more. And if you feel like you can convince them, then don't run them off for cause. Just because the defense tried to sneak one in there and.
Look, I think this is a perfect example of the way I used to do it, and I know many attorneys would do. Like you said, they would hear the juror say, look, I can't be fair if your person's not paying attention where they're going or not, in the crosswalk, because they've heard the defense argue their mini opening, which in California, the judge is required to give us a short, up to 3-minute mini opening. I know a lot of states don't, but we always push for them. But yeah, so going back to that scenario is, I think back in the day, I would have just gone right immediately. So you can't be fair no matter what, we're starting behind, all that stuff. But I probably could lose a really good juror there who may be very good on damages or really angry at the defense when they hear all the facts come out. I think that's a great point.
Yeah. And Dan, in fairness to you, I was the same way. I mean, before, early in my evolution as a jury consultant, when I was kind of learning from other people and making mistakes and everything, my philosophy was probably definitely like, make it as negative as possible and, frame everything in the most negative way so that if anybody's even remotely against you, then just get rid of them. You want to get rid of them. But I found like, not only is that like kind of, it kind of filters down to all your jurors too, but also, why are we getting rid of a juror that, really at the end of the day would probably be great for you? Just because if you kind of make it sound weak and you kind of mislead them a little bit, they tell you that they don't like your case. I mean, I used to be all about like present it in the most negative way possible before opening statement and jury selection and mini opening and, call it emotional distress when you could call it something else a little bit better and make your plaintiff sound like a whiner and don't really even mention any of the good facts or even allude to them. So I definitely was that way before, but I think that more and more, one of the things we're going to teach is like, how do you stay positive and you kind of ride that line between don't oversell your case, but don't drastically undersell your case either.
So what are the good facts that you don't want coming out then? Like what are the good stuff that you're worried will expose all the good jurors? Like what's the stuff that you'll tell the attorney, hey, keep that in the back pocket until your opening statement?
Honestly, a mini opening, it's pretty much everything, to be honest with you.
Okay.
It's like any good fact other than what you would what you would have to say for them to even have a basic understanding of the case. Like if you're, if it's a car crash and they got hurt, you got to say there was a car crash and they got hurt. But other than that, man, I'm like, don't even tell them the extent of the injuries, even if they're serious. You don't need to in a mini opening before jury selection. I mean, you'll get there in your
like
opening.
Instead of brain injury, say they had a head injury, they hit their head, something like that.
You can, yeah.
Or
I mean,
would you talk about?
if it's disputed, I'd mention it. Yeah, if it's disputed, I would say, hey, we allege that there's a brain injury, and the defense is going to tell you that there isn't, and you're going to hear about from all the doctors and everything. But if it's something like a fact, like if like I wouldn't mention like this person had a brain bleed at the hospital and they had to drain the blood from their skull. I mean, even that is like, whoa, you probably just convinced some of the jurors that this is a legitimate brain injury, and they're going to tell you so. So, for me, it's like, get out all your bad facts. Don't mention a single one of your good facts, and but kind of replace all those good facts with like sort of a weird promise. Like, instead of saying that, you're going to hear what the doctors at the hospital found, with the brain, and so instead of saying that there was a brain bleed, or instead of saying like, the defendant was speeding and ran a red light, you're going to be like, you're going to hear what the defendant driver was doing, and if they followed or didn't follow the rules of the road. So just take out all those bad facts and replace it with like this promise, like you're going to hear all the facts, so that the jurors are kind of focused on what's important and they're kind of curious about it. So that when you give your opening, they're like, your good jurors are like, holy shit, this case is a lot better than I thought it was. And you see these eyes pop, and David deRubertis is a big, he every time we pick a jury, he always says this. He's like, man, their jaws dropped and their eyes went wide, and they were like, I had no idea. And then that's when you really got them, when you undersell it a little bit.
Yeah. So I just want to make sure we're clear here. When we talk about, we got too many, or there was a lot of excitement or pressure to get as many cause as possible. We're not saying don't introduce or talk about your bad facts, because the bad facts you have to still do. I just want to make sure we're clear on that you have to, at least in the mini opening, and if you don't have a mini opening during jury selection, talk about the bad things in your case. But that doesn't necessarily mean the next step is to get as many cause as you can. You just kind of throw it back at them like, well, are you open to the idea that this is a very serious injury worth millions of dollars, or something like that, right? Is that kind of what you're saying?
Yeah, exactly. I mean, if there's a bad fact that you're just thinking like that's going to be a deal breaker, I would voir dire on that. Like, who feels like this is a deal breaker? Who feels like, the classic, like, my plaintiff was had 2 beers that night at dinner. Who feels like that's a deal breaker? No matter what the defendant did, this plaintiff is at fault for this crash. Like, and it doesn't matter. Like, but a lot of your good jurors will be like, well, it doesn't not matter. And you're not asking them like, who's going to just totally disregard that? Of course, they're not going to disregard it. But who's got such strong feelings about drinking and driving? It's going to totally cloud your judgment of what both sides did in the case. I think that's kind of where you want to go with it. But there are probably some things in your case that will be deal breakers that you definitely got to voir dire on. And I'm not saying there aren't some cases where you shouldn't be trying to get as much cause as you can, as long as you're kind of doing it as long as you're always saying, there's all this other stuff you're going to hear about, and you can even sort of, without telling them the facts, like kind of tell them what it's about. There's all these other facts about what the defendant did and what they knew, and what this company knew about how well trained they were, or about any other issues with. Are you telling me that, hey, I don't care what I hear about that? I already decided the plaintiff's at fault, no matter what that other evidence is. And some jurors will say, yeah, and those are the jurors you really want off.
I also think the important thing is make sure they're a cause juror. Make sure they're truly biased against your case, before you kick them off. Make sure they're a bad juror for you. And again, if you're too quick to go down the cause path and you haven't explored it enough, and that's another point, is that, a juror may say this thing about the crosswalk, the hypothetical we're using. And I think if that's one of the first jurors you talk to and you have the time to do it, even if they are a juror you imagine going for cause, I don't think you try to do the cause there. I think you take that juror, bounce it off other jurors, who else, sort of agrees with this or feels this way to any degree, and then find out who else is, and then bounce back to that person again, and then maybe on damages or whatever, and then you maybe they are a really bad juror. Maybe you have some other, ways to get cause, and maybe the crosswalk thing may be one of them. But I think, like you said, I'd see too many lawyers. I used to be one of them who make the mistake of going in for the kill too quick, too early, without really getting to know the person, and then allowing that person to be the the bounce board, I guess you could say, for the other jurors, to bounce off the questions with.
Yeah, and that's a great.
What do you
that's a great
think?
point that you do it. Because Dan, one of the things that you're so great about in voir dire is like showing the jurors that you're listening. You're not doing a ton of talking at them. You're listening to them, and you're showing them that you're like engaged with what they have to say, and that's what jurors like to hear. They don't want if they see a lawyer pounce on the first person that talks and get grilled and you can't be fair, right? Like, then they're like, oh, would you want to talk? If that's what, like, I signed up for this, like, interrogation session. So you're right. That should probably come a little bit later, but you're right. Assessing them first. I've seen a lot of lawyers, ask jurors about an experience, like who here has ever, been sued for a car crash before. And someone's like, oh, one time, that happened to me. And then they just jump right into like, so does that mean you can't be fair? Are we behind? And the jurors are like, what? Why? And oh, I'm sorry. I was wrong about that. Like make sure that they, talk to them first and listen to them first. And only when they really tell you like, I don't like lawsuits, I don't like this kind of lawsuit or whatever it is, only then do you really kind of politely go after them. Don't force anything, for sure.
Yeah, the whole thing with listening, I'm sure we'll spend a lot of time with. That's still something I struggle with. I've gotten better because I've had to force myself, but I used to be even, a few years ago, I would be listening but thinking of my next question and be like, oh shit, they're gonna go here, so I have to go there, and then like thinking about the script or whatever stupid thing or what, not stupid, but it's just like I would think too much about where's my next question? What is the next wording I'm going to use? And then they would say something and I'd just be like, okay, thanks. And just move on. And it takes a lot of work and I still struggle with it. I still have to really get myself to be present in the moment. We do a ton of focus groups in the last 2 years. I really made it a point in our office to do as many focus groups as we can on every case.
And you do
not
focus
only
groups,
because
right,
I think
you're doing
it's
the voir dire, right, Dan? It's not just like a focus.
Oh yeah,
group,
no,
like,
I
here's the case.
require. The requirement in my office is that every time we get a group of people here, and we're doing probably, I don't know, 5 a month now, in a heavy trial month more. So we have people, we do them ourselves. I know you guys are pretty busy now, but we recruit the jurors. They come to our conference room, and we just run them ourselves. And Harry and Claire Plotkin have a great focus group company too. They're fantastic, but. The requirement is not only just to learn, you have to learn about the fact, like how a jury analyzes your case. But to me, as a trial lawyer, every time you have the opportunity to practice your voir dire, we 100% do it. And everyone in my office does it. The attorneys do, because that's the hardest skill to learn. And like anything else, being in front of a juror is like batting practice, right? The more reps you get in, the easier it is, the more you're able to work on your active listening, because that's one of the most important skills in jury selection. And, it's hard to practice day to day. We all should be doing it. My wife would wish I did it better and more, but, in front of an actual focus group, in front of jurors, you can really practice it. You can see how you respond to things, deal with bombs they throw at you, and how you can pivot to it. So I highly recommend it. If you can ever get captive group of people and do your own focus groups, don't just do that case. Practice your voir dire. Super important.
Yeah. Dan, should we talk about some of our sponsors and
absolutely. Let's talk about
our first one. I know we talked about, I was picking a jury a bunch of years ago in this little town called Truckee near Lake Tahoe. And I'm getting there, I'm at this little hotel, and I'm like getting on the elevator in this little town, and I'm like wearing a suit, and I'm feeling awkward. Anytime you're in like some little Hampton Inn or something in a small town, and you're wearing a suit, you feel a little awkward or whatever. And so the elevator stops, and this woman with also wearing a suit comes on. And we look at each other, and we're like, "Are you going to trial?" And it was our court reporter, Cameron Villegas, and so that's one of our awesome sponsors, KNW. Sorry, just KW, not KNW, right?
It's KW, yeah. KW Court Reporting. They're great friends. They have a great court reporting company. I literally, every single one of my trials now, it's automatic. KW does it. Their reporters are great. They are super easy to work with. getting you real time, getting you daily transcripts, finals, roughs, anything you need, which in trial transcripts are extremely important, and having a good court reporter that doesn't interrupt you or tell you to slow down. Sometimes I talk too fast, but and sometimes they have to tell me that. But it's just a great company to work with. I have not gone to trial without them doing my whole trial in probably 5 or 6 years at least. And I won't go to trial without KW Court Reporting. It's a certified women minority owned business, considered some of the leaders in the industry. They're sort of famous now, I think, Harry. And yeah.
Yeah. Oh, because of Cameron, one of her cool court reporting gigs on is it Judge Judy or Justice Judy now? Is that the name of the show?
Yeah, I should have done that research before I gave their plug, but it's one of those. It's Judy. Everyone knows Judy, she's a judge. So
I mean, of all the court reporters in the country, who did Judge Judy pick to be her court reporter on air, winning Emmys every year now? How many court reporters do you know who've won multiple Emmy awards? You know, it's Cameron and Whitney.
So they're great, and then one of the first people we called to sponsor this show. So KW Court Reporting, I highly recommend. I personally use them. The other sponsor we want to thank is Tori Owens Structured Settlements. Tori's a great friend of the plaintiff's bar. He's another good friend of mine. Is just always available if you need to do a structured settlement for your clients. He makes it very easy. I was just texting with him today about I'm going to mediation tomorrow on a high value case, and he just makes it easy for me, really puts the client at ease when it comes to the long-term, investing they need and tax savings and just really any structure they have. He's a great guy, very approachable. Like I said, very easy to get a hold of, which is important when it comes to structure settlement people. Text anytime. He's great dealing with the clients so that you don't have to deal with it, which is, it's hard to explain. Sometimes it's hard for me to understand everything they're doing, but he makes it seamless. So thanks, Tori Owens, Structured Settlements,
and you have
for
Tori's
sponsoring.
Cell phone,
Yeah.
right? You ever? I mean, that's the thing that's the thing about people like Tori and companies that work with trial lawyers, plaintiff trial lawyers, man. I mean, you got to be available 24/7 if you're working with trial lawyers. And so, yeah, I know KW, Cameron and Whitney and Tori are like that. Our third sponsor, last but not least, Kelly Deutsch at Verdict Videos is the same way. She's been working with plaintiff trial lawyers for years. And they do incredible videos. They do not just day in the life videos for trial, which I've seen bring tears to jurors' eyes in real trials and focus groups, but also, they do settlement videos for mediation, which are, super effective at sending to the defense and to mediators and getting these cases settled, even pre-lit or early on before trial. But like, I remember one time recently, my wife, Claire, who's also a jury consultant, for those of you who don't know Claire, but she actually focus grouped a case where they had done a day in the life video for this case, and they actually showed it to the jurors. Actually, they did the case. They talked to the jurors and got how much damages. Then they showed them the video, and they came back with like tens of $1 million more after watching that video. They were like, This is a day in the life video they showed after the lawyers did the focus group. Yeah, exactly. And they were like, does anyone want to change at all? Does that change? And they were like, all the jurors were like, yeah, I want to add I want to take it from like 7 million to like 17 million after watching that video. Because mean, that's how powerful they are. And so I know one of the things Kelly always tells me is that they really like to be honest with trial lawyers about whether they can help or not. I know there's cases where she said, I don't think this will help you. And so, I mean, she's like me. I do the same thing sometimes. If I feel like I can't help, I'm not going to be like, okay, I'll take your money, whatever. I know she said her motto is, video can hurt you as much as it can help you. So, she's always another one who, call Kelly at Verdict Videos and see if she can help. And a lot of times they really can. They're powerful videos. Do you sometimes do settlement?
Yeah. No,
videos?
She's fantastic. I mean, she really, she knows how to tell a story through that medium, which I think nowadays jurors sort of expect, frankly, and it does really increase the value. And she's such a warm, kind person. And I've seen her where she talks about a case that she just filmed and she'll start tearing up because she really cares about what they've gone through. And someone that's like that knows how to tell a good story because she feels it. She's such an empathetic person. Another shout out to Kelly is she's always a huge supporter of Los Angeles Trial Lawyers Charities, LATLC, which is made up of plaintiff trial lawyers. Great organization. I was fortunate to be past president a few years ago, but she's a huge supporter of that organization and many others. So KW, Tori Owens, Verdict Videos, thank you so much, and please use them. We use them in my office, so yeah, cannot thank them enough. And I just want to give a major shout out to Robert from Law Pods. They have been fantastic to work with. This is my first podcast ever. Harry, I don't know if you're a big podcast guy, but they've been fantastic. Really appreciate the people at Law Pods making it easy for us busy trial lawyers to put something like this together that hopefully helps you all learn. So thank you.
So Dan, let me ask you this.
Yeah, go ahead.
What is something, I mean, we're going to be talking a lot during these podcasts with guests about something that's kind of changed in their approach, something that they, in jury selection, that they used to do one way, and then they all of a sudden learn, you know what, they do it totally differently than they did it 5 or 10 years ago or whatever, or things that they do totally differently than everybody else does. You know, they're like, everybody else is talking about burden of proof and I'm doing something totally the opposite. You know, what for you is something that, you know, has changed in your approach in jury selection in the last, you know, 3 years or
in the last I'd say the biggest thing that I got from you that I really like is how to frame non-economic damages and the value of them in the way I ask the question. And it really centers around the phrasing and the terminology that you know, I've used through your advice is, don't call it pain and suffering or anything like that. You frame it around the loss of quality of life and what is the value of someone's loss of the quality of their life. And I think that it's very important for multiple reasons because one, and Harry, you can correct me if I'm wrong, but one, when jurors hear the pain and suffering and all that, I think that the tort reform industry, insurance companies have done such a good job of saying pain and suffering, that's ridiculous, it's bullshit, millions of dollars for aches and pains or whatever. Just pain and suffering, the phrase has just become so synonymous with greedy, you know, slippin' Jimmy type, you know, plaintiff. And so I think by framing it as a loss of quality of life, and when you get pushback, it's not really a cause challenge or a strike question the way you frame it. I think it's more of getting them to understand that there's nothing more valuable than the loss of quality of life. And the way we kind of approach that, and you almost toss it back to the jurors that, you know, may have trouble with it or trouble. You think they could be good jurors. You think that they have the capacity to award a significant amount of money in the millions of dollars or whatever your aim is, but they're very hesitant about money for that. They don't understand it, like most people don't, frankly, and they don't understand how they could do it. And so when they're a little hesitant on them, but they're not someone you really want to attack for cause, you just kind of throw, you know, well, let me ask you, do you think there's anything more valuable than the loss of quality of life? And, you know, they always pause, and almost every time they'll say no, or if one does kind of hesitate, or even one that may be decent is like, you know, do you think loss of quality of life could be worth more than a lifetime of paychecks or a mansion, a yacht, or any material thing we could own? And, you know, and then so you kind of just, you get that discussion going, which is all this stuff I've gotten straight from you, Harry, which is just great. But, you know, so that's I've really changed that, because I think before I would approach, you know, you hear millions of dollars for pain and suffering, and that, you know, that rubs a lot of people the wrong way. Does that rub anyone here the wrong way? And I still may do that sometimes in a different way, but I think that would be sort of the way I would introduce the subject. And honestly, sometimes doing it that way, you honestly may be misled by some good jurors who will say, another example in that pedestrian case, we had a juror who was a preschool teacher who I was kind of asked the question more aggressively on caps or millions of dollars. Who thinks that's ridiculous? Like, my uncle, I don't know, thinks that's ridiculous. Anyone else agree with my uncle that millions of dollars for pain and suffering is ridiculous? Does anyone have a cap? And she was like, she's just a sweet like mom of young kids and a preschool teacher. She's like, yeah, I don't know. I think I may have a cap. And I was like, oh, really? Like, what's your cap? And she says, I think, I don't know. I think $1 to $2 million would probably be my cap. So in that moment, like, I think we were like heading into a break, but in that moment, my instincts, if, Harry hadn't been there or I had, I would have gone for cause on her. It's just like, no matter what the evidence shows, blah, 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 you cannot go above $2 million. That's your cap, no matter what the evidence shows. And didn't just try to get cause. This judge was giving cause like candy, so probably would have gotten it. But we had a break, or we broke for lunch before I really had a chance to follow up. And I was like, Harry, we got to get rid of her. Like, she's got a cap at $2 million. Do you remember what you told me?
I do, yeah. I remember saying like, "Oh no, that one we're not going after for cause. We're not going to make a cause challenge." And I was like,
because what are you talking about?
Because I've seen it before. I mean, a lot of assessing jurors is like really listening closely to what they really mean and how they say it and everything. And so that to me was very different from a juror who's like, "No, I mean like millions is ridiculous, and that's and like that's like lottery money, and that would they're like are super firm about it." Most jurors, though, have never spent even 1 minute thinking about non-economic damages and why and all that's kind of quality of life and what it's worth for even like 1 second before they come in that courtroom. And then, you ask them a question and they're like, I don't know. And they're just giving you like, I mean, they're talking out of their ass a little bit. They don't know. And I could tell with that woman, she was great on like pedestrian safety. She was great about caring about other people, all that stuff. And so when she was doing it, I just remember she was just kind of trying her best. Like, I don't know, I guess. Like, I guess there would be a cap. And I guess, how much would the cap be? And I guess 2 million. You could just tell it hadn't occurred to her. But anyway, and I see that from time to time. I mean, it's a tough question for jurors to answer, but, you kind of have to note the difference between someone who's like super firm and kind of angry about it versus somebody who's just kind of guessing for you and taking all those other things into account, like what she's like. Because Dan, I mean, remember she was on our jury, right?
Oh, she wanted to award like the most. She wanted to award like $25 million. It was crazy. Like, she was by far the best juror on damages. And I think another thing you said is that, look, if her cap is kind of went from $1 million to $2 million real quick in her head, like she's already thinking in the millions of dollars is kind of, a cap. And I think one of the biggest points I really want to underline is that you said, Harry, it's really how the person says it and their body language, and they respond to those type of questions on when it comes to millions of dollars. Because the case we tried in San Mateo recently, like there were some jurors who were like, CEOs of engineering corporations. You could just tell they were just like very like, $5 million in our actuary tables is for a life of a motorcyclist. Like, absolutely not. Like, you just tell just the tone, their mannerism, everything, all the stuff that you pick up on. And I think she was definitely one of those who was just like, I don't know, like I'm struggling with, I don't know, never thought about it, which is really important advice.
Yeah. I recently
but Harry, I do want to kind of
go ahead.
Or go ahead.
I was going to say,
no, go ahead.
I recently had a jury in Fresno. It's probably the only time I've ever seen them not really act really well to like, is quality of life important? And I don't know. And like two of them were like, like you were describing the CFO. There was one guy who was like, I think he was a CFO or something like that, who was like, what do you mean? What do you even mean by quality of life? Like, it's like, wow, okay. Because usually you get a pretty warm reception from that question. But, for me, and this is something that we'll teach, I'm sure, in other episodes, but like, what does it mean when a juror kind of dodges a question? How do you figure out when a juror's
or
not
throws it
totally
back at
honest
you
with you? Yeah. What does it mean when how can you tell when they're withholding or they're not telling you the full truth? Because one of the worries I think a lot of lawyers have is like, how do you tell when a juror is lying to you and trying to get on the jury? I mean, I don't think they intentionally do it very often, but it happens all the time that they withhold for sure. And so, yeah, context and how they say it and their tone is a huge part of it. And so, you can tell the difference between someone who's pissed off and someone who's confused.
That's definitely something I want to explore with some of these trial lawyers that we got coming up. But and I do want to drill down into the philosophy behind loss of quality of life, first pain and suffering, and why those words matter and how they matter, frankly, when you get into your case and how you use that as a term. Because that loss of quality of life, if you really internalize it yourself, there really is nothing more valuable than quality of life to yourself, to your family. And then that has to translate throughout how your theme of the case is. And then you'll be surprised when I started using it, I started getting more and more jurors after the verdict came in and they talked to us. They would just constantly throw that out there. Yeah, the quality of life was really bad, or the quality of life really changed, or lost the quality of life. Or if it wasn't a huge verdict or not even a great verdict, they may say the quality of life didn't really change that much, you know? So, but regardless, I think you got to get them thinking in those terms and away from the pain and suffering terminology that you used to use in jury selection.
Yeah. And that's a big difference between conservative jurors and other jurors. I mean, if you try a case in, some super bougie, downtown LA or Santa Monica or something where, cosmopolitan place, you may get away with talking about pain and suffering because they may say, I don't know, pain and suffering is serious. But you talk to conservative jurors and rural jurors and things like that, and you ask them, how do you feel about emotional distress and they go, oh my God, they like gag or something. And you talk to, pain and suffering, and they go like millions for pain and suffering is kind of ridiculous. But then you say, what about quality of life? And it's the same thing, but they go, oh, nothing's more important than quality of life. And when you talk to them about it in jury selection, they'll keep redefining it for you. I mean, they'll throw things in there that you probably haven't thought of sometimes. It's like a free focus group. It's like, I remember one juror saying like, to me, quality of life is like, just not having to worry about stuff. That's huge. I mean, and when you're always worrying about your health or you're paying your medical bills or things like that, I mean, that's quality of life, even without an injury or whatever. So,
I've gotten a good night's sleep is I just want to be rested. That's quality of life for me. And then I think that's 100% true, because you're going to use a lot of their answers. And then if they apply to your plaintiff, those are going to be in your closing arguments when you're breaking down the damages you're going to ask for, right? Because your plaintiff lost a lot of the stuff that they consider to be important for someone's quality of life.
Oh, for sure.
Yeah. And we're going to drill down on all this in the episodes to come about how do you deal with is a billionaire's quality of life worth more than the minimum wage janitor, for example? How do you get a jury in jury selection? There's ways to ask that question about is someone's pain worth more or less depending on how much they earn or what their paycheck is. So we're gonna drill into all that stuff, the different phrasing that attorneys use, the way because all these great trial lawyers we're gonna talk to, they all have very unique ways they do it from each other. I mean, Harry, you know more. I mean, you've probably picked over 1,000 plus jurors in your career. I mean, you see them more than anyone else. And there's certain things that work and don't, but there's also an art to it, right? I mean, there's also a way that's not just formulaic or a science. There's an art to doing a quality jury selection, wouldn't you say?
100%. Yeah. No, it can't be. I mean, it can't be a formula. I mean, just the fact that your jurors don't have a script alone is enough to tell you that you're never going to be able to stick to a script, even if you have a script. So you gotta listen to them. But I mean, there's so many different ways. There's no one right way to pick a jury, but how do you mix in, depending on the facts of your case, how do you mix in, some, preconditioning and getting jurors for cause and listening to your other jurors and framing and talking about introducing all these different concepts, especially if you have a judge who's like strict on time or strict on what you can talk about. How do you get creative if a judge shuts you down on certain things? I mean, I've had judges who will not let you talk about, dollar figures, don't know specifics, can't even say millions. I've had judges who have said, I had one or two that said like, you can't talk about anything that has to do with the facts of the case, like meaning like if it's a case that involved a motorcycle helmet, we couldn't ask like, do you drive a motorcycle or do you wear a helmet? No, that's going to be a facted issue in this case. So you can't even, we're like, what, So how do you roll with the punches when you have a judge that's like taking stuff out of your arsenal? And the truth is, you got to have a bunch of different tools and things to do. But, that's what I'm so excited about, is getting some of the best trial lawyers in the country, sharing some real specific things that they do differently so that you don't have to go around the country watching, jury selections in every state. So, kind of the best ways to do things and the newest ways to do things.
Yeah. I mean, I think that's the biggest thing we're trying to really help other attorneys out with this podcast, is just be ready for any scenario. And because, so many people have had to deal with it. Harry's seen every which way possible, and you're going to be faced with it. You're going to be faced with judges that are like that. You're going to be faced with a defense attorney who's constantly objecting during jury selection. You're going to deal with jurors who hate your case, even if you did like no matter what you could do, there's angry jurors, there's outspoken jurors, and it's something we all deal with. And there's a lot of comfort in that, knowing that all these attorneys that we're going to speak with and so many out there have had to deal with the same thing. And you're not unique. We've all fumbled on our words. We've all asked bad questions, and it's just about how you deal with it and how you recover and, to get you to pick your best jury possible. So with that, Harry, any final thoughts on episode 1?
Oh gosh. I mean, get ready to learn a lot of things that maybe that you're doing wrong, or things that we see, lawyers doing wrong. And our guests are going to be, that's basically the number one topic, is like, what are people doing wrong out there that you see? Why do you do it differently, and why? And be open-minded in hearing these things, because I mean, our goal after, you watch at least a few of these episodes is to totally revamp your jury selection, which isn't easy to do. But, if you've just sort of been, learning by conventional wisdom, there's probably a lot of things you could do better. So I hope you have thick skin, and hope you're ready to learn.
Yeah, absolutely. Can't wait to get this going. Thank you, Harry. And we're excited for our first round of guests. Like I said, we already have Arash Homampour, Ebieri Seck, Steve Vardazarian, Courtney Rowley, Natalie Weatherford, Gary Dordick, getting Joe Freed, Ricardo Echeverria. We're getting all these people to come talk to us about their experiences, and everyone's really excited for this. So thank you for tuning in. We'll see you next time.
Thanks, everybody.
If you're enjoying the podcast, the best compliment you can give us is sharing it with a colleague who would find it valuable. For all the best clips from the podcast, follow us on social media. You can find those links in the show notes. Have a jury selection story to share? Email us at podcast@pickingjustice.com, and we may address it in a future episode. Until next time, remember, you're not just picking a jury, you're picking justice. Produced and powered by Law Pods.